Yo, it's JP. All right, I'm going to talk about jurisdiction, okay, and the importance of jurisdiction. So without further ado, let's just get into it, okay? You can have the same exact case, the same exact facts, the same exact law in federal courts, but those federal courts are in different parts of the country, and you're going to get a completely different outcome. Okay. What that means is, one, it's a systemic problem. Okay. Because if there is federal law and that law actually means something, the words have meaning. It is a law. The law matters. It's a real thing. It's not a made up gobbledygook fabricated thing. It's a real thing. Then if you have the same facts, the same law, the same claim, and you file that case in the federal court for the Middle District of Florida, for instance, and you have the same facts, same thing, right? And you file that case in the District of New Jersey. If the law works correctly and is applied correctly and is applied in a fair, impartial, balanced, unbiased, even-handed fashion, then you should expect to get the same outcome, at least up until trial. Because at trial, you have different jury pools, okay? If it's a jury trial, the folks deciding the case are going to come from different jury pools. The Middle District, right, you have Tampa, Clearwater, Orlando. New Jersey, very different jury pool, okay? So that can explain your variation for the ultimate outcome at a jury trial. But short of that, if we're talking about summary judgment, you'll see tremendous variation in summary judgment outcomes where that variation should not exist. If the law is a real thing, and people talk about law and order and the rule of law and the importance of law and the integrity of the legal system, if that is real, we should see the same outcome on the same case, whether that case is filed in the Middle District of Florida, the District of Oklahoma, the Northern District of Illinois, the District of New Jersey, the District of Maryland. We should see the same outcome at the summary judgment stage. The problem is we don't see that. We don't see that, particularly in the employment discrimination space. So when it comes to race discrimination in particular, age discrimination, religious discrimination, disability discrimination, sexual harassment, hostile work environment, retaliation, when it comes to these types of cases, we are seeing too much of a divergence of outcomes between, take a guess, federal courts in certain parts of the Old South and federal courts in the rest of the country. Okay? And that is a problem. That is a problem because the law is the same. If we're talking about Title VII, Title VII. If we're talking about the original Civil Rights Act of 1866, 42 U.S.C. 1981, that is a federal law. It is the same exact law. And the rules, right, summary judgment, for instance, that is Rule 56 of the Federal Rules of Civil Procedure. You see what I'm doing here, right? You see what I'm doing? There was a civil war fought in this country, not just over slavery and economics and everything else, and to keep the Union together, but part of why there was a civil war and had to be a civil war was because you had the Confederacy refusing to abide federal law and respect the principles of federalism. And you saw that again in the 1960s with the Civil Rights Movement. You saw how, the federal government out of D.C. had to go into the South and force integration. And I maintain, one, I'm not just a lawyer, okay? I'm also a public figure, an intellectual, a writer, and on and on. But one of my theories or a premise that I maintain that explains some of this is we're looking at a continuation of that. There are certain parts of the American South where the law has not been applied consistently with how the rest of the country is applying it. And if we take things seriously like integrity and the rule of law, and we believe that law is a real thing and that there are principles and it matters and it's true and we're going to be honest about it, we need to bring these parts of the country into compliance with federal law and how the federal law is applied. Because if you have the same facts and the same claim under the same federal law, which is uniform across the country, then decisions at the summary judgment stage in employment discrimination cases should be the same. But they're not. They're not. You take a case, and a case where the court would basically laugh the defendant out of court for seeking summary judgment and tell them clearly you don't get summary judgment. There are disputed facts. In fact, there's a strong evidentiary record here, and the case is going to go to trial and you're wasting everybody's time. You take that same case and you move it from Maryland, New Jersey, Illinois, you move it to certain federal courts in the South, and they are going to grant summary judgment in that exact same case. And that's a problem. And so what we're doing, okay, to address that, one, we have to address it. And then two, we have to be real about the market and the business realities and the practical realities of running a law firm in that sort of environment, okay? So the way we're addressing that, one, in the plaintiff side employment cases, right, discrimination, retaliation, sexual harassment, very few lawyers who are on the plaintiff side of those cases are willing to go the distance, okay? You have a lot of firms that are settlement mills. And so folks will just settle cases out for whatever they can get, even if it's peanuts for a real case. And the reason why you have settlement mills like that is because of this structure. You have these broader structural failures, right? If it was a market, these are market failures, okay? But these are failures of the legal system, all right? So you have a lot of folks who are plaintiff side employment lawyers, they run settlement mills. That's why so many people contact our office and they say things like, I have a lawyer, but he's not willing to go to court, okay? And I know a lot of people watch my videos. I know there are big law firms and corporate lawyers, even judges watch my videos because everybody's watching what I have to say, probably to try and, come after me over it, which they've done before, right? But people have tried that and they have failed and they will keep trying and they will keep failing. And I have First Amendment counsel, I have bar counsel, I have all kinds of counsel. But the problem is the legal system is not functioning correctly. It's created this market failure. And so now you have all these cases that are real cases and plaintiff side employment lawyers just settle them out pre-suit for peanuts. That's why you have people reaching out who say, I can't find a lawyer to represent me. I have a case. I had a lawyer who was willing to do an EEOC charge or send a demand letter, but they're not willing to actually file a lawsuit and litigate the case. Why? Because federal courts in certain parts of the country are not properly applying Rule 56. They are granting summary judgment, particularly in employment discrimination cases where folks have a viable employment discrimination claim where they have enough evidence that they should be permitted under the rules to go to trial. That is happening time and time again. And that's not me making it up, okay? That's Tynes, all right, out of the 11th Circuit Court of Appeals. I have a really important point to make, right? To all the folks who are watching, okay, including my enemies, right? Contrary to the reputation that some folks believe the 11th Circuit has, I have to tell you the 11th Circuit is ardently against discrimination. The 11th Circuit has made crystal clear that if a plaintiff comes forward and they have evidence from which a jury could reasonably conclude that they were discriminated against or retaliated against on the basis of race, disability, age, what have you, right? If the plaintiff has evidence and there are material facts in dispute, the 11th Circuit is actually fantastic on that issue. The 11th Circuit is actually fantastic on that issue. And the chief judge of the 11th Circuit is staunchly against racism. And yet you have a lot of folks say, oh, the 11th Circuit, it's not favorable for discrimination plaintiffs. No, the 11th Circuit is just not favorable for people who have workplace grievances. And nor should they be. Because the law is not intended to remedy workplace grievances. The law is intended to remedy violations of people's legal rights, not intended to police workplace grievances. It's a completely different thing. There is no law against folks being a jerk. There is no law against your boss being a meanie, right? Inappropriate, unfair, unfortunate, but it's not against the law. Law is about rights, not about feelings. And so the 11th Circuit is staunchly against discrimination. The chief judge of the 11th Circuit is staunchly against racism. And it is a very fair court. But the problem is the 11th Circuit jurisprudence has yet to trickle down to many of the district courts within that particular circuit. And this happens other places throughout the South. I've seen this happen in some courts out of Texas where, certain courts, federal courts in Texas that I've monitored and followed, getting past summary judgment in an employment discrimination case has become this Herculean task, which is a near impossibility. And I've seen that play out in the market meaning the actual cases we're involved in, right? We've had so many opposing counsel come to us or come to me or my colleagues and say, you'll never get past summary judgment. Well, why? Why? This just goes to show you how naive and gullible I am, right? 2 years ago, when we started doing a high number of plaintiff side employment cases, first I had to go out and pivot to that, right? Because we do all the non-compete and trade secret defense, and we got gobs of that coming in all the time. We already established that sort of piece of the market and that particular presence in the market. I had to build the whole new wheelhouse to get the plaintiff side employment cases. And so I did that. And I invested a bunch of time and a bunch of money in it. And in making that move and in building out that new area of the practice, I had studied the actual statutory law, the text of the statutes. And then I had studied the appellate case law out of the United States Court of Appeals for the 11th Circuit and the United States Supreme Court, okay? And based on studying the statutory law, the appellate case law from the 11th Circuit and the Supreme Court, and even in some instances reading legislative history, I was like, okay, I understand what a real case is. I understand what the law requires, what's a strong case, what's going to, survive summary judgment. Okay, so now I know how to select these cases. Well, I was wrong. Because I was selecting cases based on the 11th Circuit and the Supreme Court and the legislative history, the real law. I was not selecting cases based on what the federal trial courts throughout much of Florida were doing, which in my view is not in line with what the 11th Circuit has required. In the 11th Circuit, there are recent cases in the past 2 or 3 years where the 11th Circuit is basically saying, like, hey, folks, Rule 56, that's the rule, right? If there are no material facts in dispute, then you can grant summary judgment. But if there are material facts in dispute, that's what a trial is for. And so this is a problem in the legal system. This has created all sorts of market failures, okay? And so we are addressing that. And the only way you address that is you have to be willing to go through the process, take your chance at summary judgment, lose, and then go up on appeal, okay? Most lawyers aren't going to do that for a variety of reasons. One, that requires that they even do appellate work. And a lot of folks just don't do federal appellate work because it's very technical and there are all sorts of rules and requirements. And a lot of people, plaintiff side employment lawyers, they're just not built to do that sort of work, okay? That's one. Two, there's the cost of it. In terms of the sheer cost in terms of time, all right? The time you spend in the trial court. Then if you lose at summary judgment, now you're doing an appeal. Now you're up in the appellate court, okay? Three, in many of these cases, okay, and I consider this particularly nefarious, the defendants have come to me or my colleagues, and they have threatened to garnish my client's wages over what's called a cost judgment. So under the federal rules, the prevailing party in litigation is entitled to recover what is called taxable costs. Your taxable costs are things like filing fees, deposition transcripts, that sort of thing. Okay, there's a limited universe of what are called taxable costs. And under the federal rules, the prevailing party is entitled to recover their taxable court costs. And so oftentimes these taxable court costs wind up being $4,000, $5,000, $6,000, $7,000. And it's not a tremendous sum of money. But when we're talking about an individual, right, a working person, a middle-class person, it is a tremendous sum of money. And so these corporate defendants and via their counsel, they come to me and they say, well, when we win summary judgment, we're going to garnish your client's wages. We're going to bankrupt that guy, okay? And I don't like that. Because yes, they technically are allowed to do that, and that is technically a risk, but I don't like that because you're basically scaring poor folks and working folks and middle-class people into not taking a stand and trying to vindicate their rights. And so then I gotta, right, and I explain this stuff to my clients. I gotta say, I gotta tell my clients, okay, look, if they get a cost judgment against you, I'll figure it out, okay? I'll figure it out. I'll do a GoFundMe, right? Or I'll figure out how I can permissibly bond it, so that they order, we'll move, thank God in some of our cases where it actually has come, right? It's come to the forefront. It's been an issue. Thank goodness that, certain judges have granted forbearance on that pending appeals, right? But that's a really big problem. And I think it really is. I think it really is ugly, right? A poor working person is making $13, $15 an hour, go through a case. And in my view, they have a real case, and they have a case that was improperly disposed of at summary judgment in violation of binding 11th Circuit law and Supreme Court law and the actual statute. And then the other side says we're coming to garnish your wages and we're going to bankrupt you over a $6,000 or $7,000 cost judgment. I don't like that. It doesn't sit well with me. And in fact, it shouldn't sit well with anybody in America who cares about justice, fairness, integrity of the system. Okay? And so this is one of the reasons why, and again, lots of people watch what I have to say. Some of them because they're grudgingly, they're like, damn it, this Pollard guy, really, he does have some points. Other people because they're just watching for me to say something where they can try and run into court and get a gag order on me or go to the bar or whatever. But, look, folks, I'm adamant. I'm not just a lawyer who bills hours and pushes paper. I'm a crusader. I'm a reformer. I'm educating the public, and I have a First Amendment right to do all this and talk about all of this, okay? There's a reason why I have 80-some thousand people who follow me on LinkedIn. There's a reason why, people reach out to me. I've had folks reach out to me, some of the most famous, powerful people in the world. They reach out to me like, Power, can you help with X, Y, Z? And I'm just like, well, how the heck? And they're like, oh, no. I've been watching what you have to say. I've been listening to what you have to say, and you're on it. Because I'm on it. But what all this does, is all these systemic failures, structural failures, market failures, incorrect application of the law. What this does is this creates a system where for the past 20 or 30 years, federal courts throughout, certain parts of the American South, they have been incorrectly applying Rule 56 in discrimination cases. They have been summary judgmenting discrimination cases, employment discrimination cases that should have gone to trial. And they never got corrected on this because of the economic realities. Because most lawyers and law firms aren't going to fund all the costs and expenses and overhead and time and man hours that it requires to go to summary judgment in the first place, then lose, then take an appeal, then come back down and keep going. Especially when on the back end, the corporate defendants will go into court and scream like smashed cats about the plaintiff side employment lawyers' fees. They'll say, these fees are outlandish. They're extortionate. This is a greedy plaintiff side lawyer, right? How many times? I cannot count the number of times, right? When I've basically been out there running a one-man charity, right? And not a charity proper in the proper sense, but like taking all sorts of cases for people where it's like they have no money, right? And either we would do cases either low bono or pro bono, and we basically be like, look, I know you can't pay, but like, this is a real case, and we're going to represent you. I'll try to get some money out of the other side at the end. And then I got companies and their lawyers running into court saying, Your Honor, Mr. Pollard said on LinkedIn, he said he took this case for free, which means he's not allowed to get his fees. I took the case for free as pertains to Joe Smith, the client. I said it was free for him, doesn't mean it's free for you, right? You see how the emperor has no clothes. You see how this has all devolved into a bunch of shenanigans, right? I'm the good guy, right? I'm the good guy. I'm the last Boy Scout. I'm out there fighting the good fight, doing good work, working my butt off, putting it on the line, risking everything, trying to help people, pushing back against a system which is widely dysfunctional, sometimes nakedly corrupt, okay? Pushing back against it, trying to make a difference, trying to help folks, trying to educate the people, trying to educate working and middle-class people about their rights and show them how to navigate the system. And I'm willing to take on moonshot crusades and uphill battles. I'm willing to go the distance, do the appeal, go the whole process. But I'm always the one being accused of being greedy. It's usually one of two things, right? It's either I'm greedy or it's I should not be allowed to talk about the law and litigation and the legal system outside of court. And that whole line of argument, right? Don't talk about litigation in court outside of court. That entire line of argument and logic derives from a desire to keep the litigation process, the court system, to keep all of that secret and cordoned off from the public. Because what these folks like to do is they like to say, well, no, I'm not saying the courts aren't public. Sure, the courts are public. But nobody's going to go in and sit in the benches and watch. Right? Public, but in an illusory sense, in a technical sense, in an almost theoretical sense. Public, but not really so. Because if folks are permitted under the law to go in and sit on the benches and watch the proceedings and listen and go find the documents online, if they were permitted to do that, what's the difference between them doing that and me talking about the law and the litigation? When people aren't going to go sit in the courts in those benches and they're not going to go online and find the documents, and most people don't how. And if they found them, they wouldn't know what they meant. But here I am. And I majored in English at Cornell, and I was a high school English teacher in Baltimore City. And so I've been a writer, and I've published a lot of writing and been on a lot of funny pages. And I have the ability to distill all of this down and explain it to regular folks in a way that removes the hocus pocus and the smoke and mirrors, and it makes it make sense to them. And unfortunately, part of the sense that it makes is that it reveals just how broken the American legal system is. Because if you file a discrimination case, and it's a real case, and you file that, I don't care where you file it. If you file it in a federal court in Texas or South Carolina or Oklahoma or Illinois or Wisconsin or New York, if it's the same facts and the same law, you should get the same outcome at the summary judgment stage. And you're not getting it. That is a problem. That is a failure of the system, and that is something we have to correct. And so we're correcting it via doing the work of the appeals. But it makes no sense from a business standpoint to bang my head against a brick wall and have any faith in the system at this point. And so I have to have, right? You have to have your primary plan, your secondary, your tertiary, your all contingencies, right? It's what they teach. And so we're expanding into other areas and parts of the country. And as I've indicated, our next office is going to be in Frederick, Maryland. We're likely going to put an office in New Jersey at some point. But basically, we're playing jurisdictional hodgepodge here. We're looking at jurisdictions and we're saying, okay, what is a reasonable jurisdiction for us to go into where we believe that the district courts are properly applying these laws? Because if you select the types of cases you're going to pursue based on Supreme Court law and appellate case law, like I did before, right? Like, I've gotten wise. I want to look at not just what the law is per the appellate court, which is binding and controlling, and which the district courts are supposed to follow, and in fact have to follow, but often don't, okay? So I'm looking at what the district courts really do in places like Maryland and New Jersey. And so in terms of what I think are the strongest cases in Florida, like, yes, we'll still do discrimination cases in Florida because I'm going to keep working on that problem until I solve it. I've seen so much vicious racism in Florida. I mean, vitriolic, like Civil War era plantation style angry racism that needs to be corrected. I've also seen a tremendous amount of pregnancy discrimination, disability discrimination, age discrimination. All of these things are rampant. I think they're rampant to varying degrees, but like in Florida, these things are rampant and they need to be addressed. And most most lawyers just aren't gonna go out and do the hard work of addressing them. So we'll keep doing it, but we're building other markets, and I'm going to be more selective about what we take out of Florida, right? Like, the cases we take out of Florida have to kind of be, okay, this is clear-cut home run, and even if the trial court disposes of it at summary judgment, we're going to win on appeal and come back down, and we're going to keep it moving. What do I think is the strongest plaintiff side case in Florida? It's not even a discrimination claim. It's not even an employment claim. The strongest plaintiff side claim in Florida, and one of the strongest claims that I think exists in the plaintiff side in America, is a Florida claim for defamation per se. Florida common law claim for defamation per se. I'll put out a video where I talk about defamation per se, but we have one right now where it's been in litigation for the past, 18 months to 2 years. We had to go up to the 4th District Court of Appeals. We moved in the trial court to add punitive damages. The judge granted our motion to add punitive damages. The other side appealed to the 4th DCA and said, no, we shouldn't have been permitted to add punitive damages. The 4th DCA agreed with us and said, no, punitives were validly added. The case can proceed. And so now the case is going to trial. Defamation per se claims are gnarly because they permit actual, presumed, and punitive damages. They have an amazing damages framework. So the next video I do will be about defamation per se cases in Florida. But in terms of the case selection process, that's what I'm going to go heavily at in Florida. We'll still take the discrimination cases, retaliation, sexual assault, sexual harassment, etc., as long as they are really strong cases. Now, once we get the appellate law built out and we win a number of these appeals, then I'll be able to start taking cases that are more in the middle ground, right? Where they're like, hey, it looks like a real case, but it's kind of a jump ball. We'll take those. But for right now, we're going to only have to take really strong ones. Other than that, in Florida, I'm looking for the defamation per se claims, and I'll do those in a subsequent video, right? So I think if anybody watches this, including people who might hate me or be out for my head, you got to at least grant the fact that, like, I'm a true believer, okay? I'm a true believer. I went out, identified a problem, and I'm working my butt off to fix it. So no quit, no surrender. Let's keep going. Road may be rocky, won't be rocky long. Peace.